Are you sure you want to start live?
Yes.
Okay. Okay. Good morning, everyone. Welcome to AAIP's first of two May 2020 webinars. I'm Don Stewart. I'm president of the Arizona Association of Independent Paralegals, and I guess I'll be your host today, at least in between speakers. I want to start off by just going over a few details in participating or listening to the webinar. Today's webinar will be 3 hours, and it will consist of two topics. The first topic will be on LDP ethics. It's a presentation by attorney Brian Locker. The presentation is entitled The LDP Disciplinary Process and Beyond. It's going to include information about the LDP complaint process, including issues related to preparing responses, preparing for hearings, motions, special actions, and much more having to do with the disciplinary process. The second part of the process will be presented by certified legal document preparer and certified financial planner, Jim Tewalt, and his presentation is the nuts and bolts of revocable living trust. Jim will go over many issues having to deal with trust, including estate planning strategies, funding trust, and much more. During the live presentation, normally we have the ability to take in, you can participate online and ask questions through a chat feature. It doesn't appear that chat feature is active at this moment. If you do have the ability to do that, hopefully I'll see that, but I want to offer to you that you can, if you want to text me questions for the presenters, that would be fine. You can text questions to my cell at 602-619-4005. That's 602-619-4005. One other thing, and then we'll get started on the presentation. As all of you should have received some initial instructions about attendance and how to obtain a certificate of completion after the webinar, and I just want to repeat that. Basically, the way we verify that people attended is I throughout the seminar, in this particular seminar, I'll hold up 3 words, or 1 word 3 different times. 3 different words. I think you know what I'm trying to say. Anyways, I'll hold up a word just before we start the first speaker. I'll hold up a different word just before we start the second one, and then at the very end of the webinar, I'll hold up a third. And you'll want to write down these words, and then at the end of the webinar, sometime in the next day or 2 or 3, send me an email to the email that was on your instruction list, which is AAIPcontinuingeducation@gmail.com. Again, this is on the information that was sent out to you originally. Send those 3 words to me, and then I will respond with your certificate. So let's see, I think that's all the initial things I wanted to go over. Thank you for supporting AAIP and participating in our great seminars. This will be another one that I hope you appreciate. But for now, I'm going to welcome our first speaker, Brian Locker. Brian Locker from the law firm of Fowler St. Clair, who will be doing the ethics portion of our seminar. So let's welcome Brian Locker. Take it away, Brian.
Good morning, everybody. I appreciate you being here and in these interesting times where we're presenting in unconventional ways. I'm used to speaking to you from the ballroom at the Hilton in Tempe, but those of you who have attended our seminars that our office has done over the last few weeks, you'll be pretty familiar with the format, although this time I'm accompanied by a PowerPoint presentation, which I'll put up here in just a few moments. Like Don said, we normally have a Q&A feature. For whatever reason, that didn't activate on this particular webinar. We'll fix that for future presentations. But again, like Don said, you can submit questions to him, and he will interject with questions as they may come up. So let me get going here. This is a presentation I gave, I think, a couple of years ago. Might have been 2 years now, but in either event, I think it has some really helpful information. I'm going to focus my presentation, probably the second half of it or so, on the actual formal hearing process that takes place in the disciplinary process through the Superior Court for LDPs, because I think last time I didn't really get to focus much of my presentation on that. But there's some groundwork that I want to lay before we get there. So I'm going to go ahead and put my presentation on the screen. Generally speaking, we've got, I'm going to be covering ethics complaints and what I believe that every LDP should know in the unfortunate event that that you have a complaint process that you are facing with the Supreme Court, and make sure that you are comfortable with that process. And before I really get going, I do want to give you some level of comfort that if you are faced with this process, it is a process that has a significant amount of protections in place, including judicial review in some cases, and so if anything, in addition to the safeguards that are in place, there are also many opportunities during this process by which you can have opportunities to have this thing ended, and in fact, the code, in my opinion, encourages the Supreme Court and LDPs and the administrative process to be settled and resolved prior to a final adjudication that results in what every LDP is concerned about, and that is suspension or revocation or non-renewal, any of these things that would affect your livelihood. And those cases, I believe, where that actually happens should and are very few and far between. And so hopefully that brings you some level of comfort. All right, so let's get going here. I'm going to cover the generic LDP responsibilities under the ACJA, cover 7201, 7208 generally, and then we'll get into the disciplinary actions. So let's talk about LDPs from a public policy standpoint. Again, if you guys attended my presentation a year or two ago on this, you'll probably remember, and you probably even know just by virtue of you being a certified legal document preparer. But the ACJA Section 7208, it recognizes the need to protect the public from possible harm caused by non-lawyers providing legal services. But in Arizona, we balance that possibility of harm with the public's need for access to legal services. That is the fundamental reason why the LDP certification exists. It exists because Arizona understands that the access to the legal system and the access to justice is important. And while there is a risk that you have folks who are representing or providing these legal services that would traditionally be handled by a lawyer, handled by non-lawyers, while there is a risk associated with that, it is outweighed in many cases, and pursuant to this code, it is outweighed by the need for legal services for folks, traditionally in the lower income brackets, the folks who would not traditionally be able to access the legal system. And so I always, try to start presentations talking about the fact that, our firm sees the LDP community very much as a partner in the Arizona legal process. And this is the reason why, right, is that in my view, we are not competitors. LDPs and lawyers are not competitors. There are some lawyers out there that believe that there is competition here, but I agree with the Supreme Court in adopting this section of the ACJ, and that is that we need to provide access to the legal system, and LDPs provide an invaluable service for the community in order to do that. So that is the public policy behind the LDP certification and why it exists. And the LDP has specific responsibilities laid out in 7208. And the first is to prepare and provide legal documents without the supervision of an attorney in any legal matter when the person or entity is not represented by an attorney. It's important to understand that there is not a limitation put in place as to which legal matters an LDP can assist. Now, there are limits to what assistance an LDP can give, obviously, but it does not discriminate as to what legal matter they can or cannot participate as a general rule. Moving on to subsection B, the LDP has a responsibility and has a role to provide general legal information, but may not provide any specific advice, opinion, or recommendation to a consumer about the possible legal rights, remedies, defenses, options, or strategies. Moving on, the LDP may provide general factual information pertaining to legal rights, procedures, or options available to a person in a legal matter when that person is not represented by an attorney, and may make legal forms and documents available to a person who is not represented by an attorney, and may file and arrange for service of legal forms and documents for a person in a legal matter when not represented by an attorney. And the roles and responsibilities must be offered and performed consistent with the legal document preparer code of conduct. So as we've gone over these different roles and responsibilities, the general question is, when should an LDP worry about a complaint? Under what circumstances does an LDP have to begin to have concern as to whether a complaint may be filed against them? I have a couple of notes on this, and obviously in a more informal presentation and where we can have back and forth and that sort of a thing, I'd obviously seek your opinions and your suggestions here. But what I think it comes down to is an LDP should worry about a complaint when the roles and responsibilities are not offered and performed consistently with the legal document preparer code of conduct, right? So to the extent that you are operating your business in conflict with these roles and responsibilities that I just went through, it is those circumstances in which an LDP should worry about a complaint being filed. Now, does that mean that you are free from ever having, you will be free from ever having a complaint filed against you, even if you follow the code of conduct and follow the ACJA? Well, no, of course not, right? Just like in the legal system where we have a judicial system and a court system where anybody can file a lawsuit against anybody for any reason, right? That there is nothing that prevents a member of the public, an officer of the court, whether that be another attorney or whether that be a court staff, some other person, from filing a complaint. There's nothing stopping them from filing a complaint. And the hope is, and we'll talk about this as we go through it, the hope is that the process that the ACJA puts in place prohibits or at least cuts down significantly the prosecution of baseless complaints. And there are a number of checks and balances that the Supreme Court has put in place to ensure that an LDP is not prosecuted or is not disciplined for conduct that is appropriate under the ACJA. So that's generally speaking what I mean by that. So let's get into the complaint process here. I break down the complaint process into 5 steps, although that might be simplifying it just a little bit. So I want to kind of draw a roadmap here of where the balance of this presentation will be going. So the first step that we'll cover here is the complaint initiation portion, where a complaint is actually filed. What does it take to file a complaint? Who do you have to be? Who must file complaints? Things of that nature. So getting the complaint started. The second portion is after the complaint has been filed, how it's screened by the board and the director and the administrative process that the Supreme Court has put in place and what happens there. Step 3 will be how, if the screening process finds that there is a substantiation for the complaint, how that complaint is then investigated by the administrative staff with the Supreme Court. And everything that goes on with the investigation. And after that's completed, we have step 4, where the LDP is finally involved in the process. Up till step 4, the LDP may not even know that a complaint has been filed against them. There is a lot of administrative process that occurs before you even know that a complaint has been filed against you, unless the person who has filed a complaint lets you know themselves. The Supreme Court will not notify the LDP until it finds that there is substantiation for the complaint itself, and some other things take place. We'll talk about that. And then finally, where I want to focus, sort of the balance of the time, is through the actual disciplinary proceedings that can take place, where we have a substantiation of the complaint, and further, we have a decision by the board to proceed with some sort of disciplinary proceedings, whether that be informal, whether that be formal, and we can talk about the difference between those. So let's get into it. Let's talk briefly about the complaint requirements. And so you'll see here, whenever possible, I cite to the appropriate ACJA section, so you can reference this at a later time. But a complaint must be in writing, sufficient specificity to warrant further investigation, and include the name, telephone number, and address of the complainant. What's important to glean from this is that one, this is not an anonymous process, right? So if someone is filing a complaint, they cannot do so confidentially. They have to tell the Supreme Court who they are in relation to the LDP. They need to act with specificity. I read this to say that this is probably a higher standard than we even have for civil complaints in many regards. In our judicial system here in Arizona, we have a notice pleading state, and requires more general, it allows for more general allegations. And this seems to me to maybe even be a higher standard than that, which is, in my opinion, good, right? We don't need generalized complaints by complainants. We want to know exactly what the allegations are for misconduct that are being alleged. Let's keep going here. So who initiates the complaint? This is kind of interesting. All judicial officers, court employees, and certificate holders shall, and any person may, notify division staff if it appears a certificate holder has violated statutes, court rules, this section or the applicable section of the ACJA. So the thing to understand here is the fact that these first few folks who are named in this subsection, judicial officers, court employees, certificate holders, so that includes all LDPs, that includes all lawyers, and it includes these court employees. They must notify division staff if it appears a certificate holder has violated statutes. That is not optional. So, for example, if I come to learn of a violation of these ACJA by a particular document preparer, I am, according to this, bound to report it. I have no option. I must. So that is interesting that sort of duty is imposed, and that is similar to the duties, at least for a lawyer, the duties imposed by a lawyer against other lawyers for ethical misconduct. There is in some cases a mandatory reporting that must take place. So the Supreme Court has opted to include that sort of requirement as well. So interesting that they do that, but any person may. And I think we're talking about the public, right? We're talking about consumers. We're talking about your customers, your clients who come and see you may and have standing to initiate a complaint. The director, so we're talking about now after a complaint has been lodged, the director may direct division staff to investigate allegations of misconduct, acts of misconduct, or violations of statutes, court rules, or the ACJA, which may result in a complaint if such investigation protects and serves the best interest of the public. Division staff shall consider whether a complaint outside of the Supreme Court's whether a complaint is outside of a Supreme Court's jurisdiction, whether there is appropriate naming of an LDP, whether and you know, you can kind of read what this says, but you know, we've reached this second portion here of the process, right? The screening of the complaint itself. So a complaint has been lodged, and the division staff, this administrative staff that the Supreme Court has set up, now need to determine, does it meet the very nuts and bolts requirements of a valid complaint, right? Is it something the Supreme Court can even consider under the ACJA? You know, like I mentioned before, does it name the LDP specifically? Does it have the specific contact information for the person making the complaint? All of these things, right? And you know, I point out here specific allegations of misconduct, but not a violation of statutes. Basically, you may have allegations of misconduct, something that the customer or the judicial officer, whoever it might be, believes is misconduct. But if it's not an actual violation of court rules or the ACJA, then that's not going to meet the requirements. And then the division staff determines whether, based on the complaint itself, whether it warrants further investigation and evaluation. If that is the case, then the process moves forward. Depending on the findings of the division staff, as outlined before, the director may have the staff send in the incomplete complaint back to the complainant for additional information. But must dismiss the complaint if the complainant fails to cure the defects in the complaint. They may dismiss it with or without prejudice, or refer the complaint to another state agency or entity with jurisdiction if appropriate. So again, we've got this screening process where I view it sort of like a funnel, right? So at the top of the funnel, you have this very wide mouth that gathers everything, right? Every complaint that's filed with the Supreme Court and the administrative agency, and as we start going through, that funnel starts to narrow, right? And you have certain certain complaints that are filed that don't meet the strict requirements that are required, and so those are thrown out or sent back to the complainant for correction. You have other complaints that may meet the strict requirements but aren't actual violations of law, and those get thrown out as well. And you start culling, or you start narrowing the amount of complaints that you're actually proceeding with. And so once we've gotten to this point, the director actually can then evaluate, even if there is maybe a violation here or there, the director importantly has an incredible amount of discretion to decide which complaints are actually prosecuted, investigated, and that sort of a thing. And that's what you see here in 7201 H2B, where it says the director has the authority to dismiss complaints with or without prejudice, or refer out to other potential agencies. If the director dismisses a complaint, the board actually will affirm the division director's dismissal or request additional investigation. These are these checks and balances that I referred to earlier. You know, it's important that you don't vest all of this power in the complaint process in one individual, right? And so if the director determines that a complaint is dismissed, the board actually will affirm that or can actually reverse and ask for additional investigation. The board shall also review dismissal if requested by complainant within 10 days of notice of dismissal by the director. And so even the complainant upon notice of a dismissal has some additional power to have a review done again. All right, so let's talk about the investigation. Let's assume that the complaint isn't dismissed and that an additional investigation is required. So if the complaint is within the Supreme Court jurisdiction and warrants further investigation, the division staff shall conduct preliminary investigation. At this point, the certificate holder is notified, which we'll talk about here in a second, and the staff will review the certificate holder's response, prepare an investigation summary, and deliver the findings of the division staff to a probable cause evaluator. This is a person that's appointed by the Supreme Court to determine whether probable cause for a violation of the ACJA or applicable statutes exists, and is part of the administrative staff who is appointed. So, like I mentioned before, as part of this preliminary investigation, the LDP is notified that a complaint has been filed against them, and they have 15 days to respond to that complaint with their side of the story. This is the first opportunity that the division staff and the Supreme Court have an opportunity to hear from the LDP about what exactly happened that gave rise to this particular complaint. And so it's very important, if you are an LDP who has been notified of a complaint, you must, and I shouldn't say you must, but you should, under all circumstances, whether or not you believe that this complaint is frivolous, baseless, any of these things, it is essential to respond to a notice from the Supreme Court that a complaint has been received and that you've been given an opportunity to respond. And you can see here the written response must be returned within 30 days unless you ask for an extension, which is plenty of time. I would also recommend, in addition to a narrative, some sort of narrative that you put together about the underlying circumstances and what exactly happened. I would submit as much supporting documentation, maybe even declarations or affidavits from other individuals, employees, things of that nature. Anything that helps clear your name with regard to the allegations that are being presented. I would take it as seriously as anything, as this is your livelihood, obviously. So let's talk about here. We've got a response, obviously, that you have submitted within the 30 days, and so now the division staff takes that, the response, they take the complaint, they take their own investigation, they prepare a summary, and they deliver it to the deputy director for or a probable cause evaluator if one has been appointed. And the deputy director will direct further investigation, find no probable cause, or find probable cause. And if they find probable cause, and I refer here to H6, 7201 H6 has a list of all the different types of violations that a legal document preparer may be subject to. And so they will either find that probable cause for one of those violations exists, that no probable cause exists, or that maybe there's some additional investigation, maybe based on the information provided by the LDP in the response, right? There might be, oh, well, okay, based on this information, it looks like we may need some more investigation as to, what may or may not have taken place in this instance. So those are the three possible outcomes from that. Finally, once there is a determination, the board then reviews. So division staff sends the investigational summary to the board, including probable cause, determination by the deputy director, and a recommendation by the director. At that point, we have a crossroad, right? Because at this point, there's been quite a bit of investigation. There's been back and forth by both sides, and the board, not the board, the administrative staff has made some sort of determination, right? And in the case that there is misconduct and that the division staff believe that misconduct has taken place, then some action needs to take place. Now, if the division staff believes that no misconduct has taken place and they recommend dismissal, I don't know of a circumstance, just briefly, I don't know of a circumstance where an administrative staff investigation has taken place and they recommend dismissal and the board comes back and says, oh no, we don't agree with that. We want you to do additional work, or we want you to XYZ, take additional action. If the division staff recommend dismissal and that no misconduct took place, I think there's a fair level of certainty there that a dismissal will then take place. So what happens if there is a recommendation of misconduct and that probable cause does exist for a violation? There's a number of things that the board can direct division staff to do. One is an advisory letter, right? So that is simply, that is the slap on the wrist. That is there was probably an issue here. There was probably a violation. It probably wasn't terribly serious. It's something that can be corrected. So a letter goes out. This is the equivalent of, working for an employer and they've put a note in your file, right? This is something that we may look on later. Should there be additional misconduct? This could be an aggravating factor at some later date. Should you continue this misconduct? But for now, it wasn't serious enough to do much more than simply letting you know that this is something you need to correct, right? So that's the advisory letter. Informal disciplinary proceedings. So we'll talk about this in more detail, but there are two different tracks that disciplinary proceedings can take if they don't simply issue an advisory letter, and that is, it can be an informal process or it can be a formal process. So we'll talk about both of those processes here in just one moment. And then also there can be an action for suspension. This is more of an emergency circumstance where there is reason to believe that there's imminent danger or harm to be harm to the public, the general public, and the board needs to take immediate action to suspend the license and then have a later determination whether that suspension should be overturned. That's in extreme circumstances. I'm not aware of circumstances where this has actually happened in Arizona in the LDP program, although it may have happened. But I don't know of circumstances where that has happened, and certainly shouldn't be something that folks who are attending a class like this probably need to worry about. So let's focus on the disciplinary proceedings here, the informal or formal disciplinary proceedings. We're now, as you can see in the top of the screen here, all of these arrows are now lit up. We're now in the final stage of the disciplinary process. We are in the disciplinary proceedings themselves. You are well aware, if this is something that you ever face, you are well aware when this process has started. You've already responded to the complaint. You've been made aware that the board has had a recommendation given to them that probable cause exists for a violation of the statutes. And now you will be made aware that the board has elected to proceed with either informal or formal disciplinary proceedings. This is what I just talked about: the emergency summary suspension, expedited hearing procedures, and that sort of a thing. Well, let's talk about the more common things that we have: the informal proceedings. So informal proceedings are deemed, if informal proceedings are deemed appropriate, the board shall set out proceedings it finds are necessary, meaning this is a flexible process and it is designed to be able to meet the needs of whatever the violation may be, right? So if the violation is slightly more serious, it might have some additional formal or more structured proceedings. If it's a less concerning violation, it may be a little bit more relaxed and more laid back, a little less structured. But in any event, the LDP does not have a right to a hearing. So this is all going to be taking place administratively, internally within the board, typically, and with the division staff, and it may result in the informal sanction with a letter of concern. So one step above this this advisory letter, right? It's an actual sanction letter of concern. It is not subject to special action proceedings, which we'll talk about in a little bit in the formal proceedings. But what that basically means is there is no judicial review. So if you disagree with this and you feel like this was an unjust process and that you want to fight this and this informal proceeding and that sort of a thing, you don't have a choice and you don't get that option. Right. This is not subject to judicial review because no formal action is going to be taken against your license, which is the other important thing to understand. If informal proceedings are followed, you do not risk suspension of your license, which is why judicial review is not granted. Right. Because if this was your livelihood on the line, you would like to think that you'd have some sort of appeal rights. Should you feel like the process did not go the way that it should have. It's also not confidential, right? So the information that comes out of an informal proceeding will be made public or will be accessible by the public, much like the and I compare this because this is my world, but this is much like disciplinary proceedings from the bar against a lawyer, right? And so if proceedings against a lawyer get to the point where there's actual discipline issued, even if it's informal, that becomes a matter of public record that consumers, the Supreme Court and the board determines, it's important for the consumers to be able to know. And so that is something that the public will be able to access, which is important to understand. So now let's talk about formal proceedings. So the board has made a determination that whatever the violation that's taken place, that it is serious enough to merit formal proceedings. The board may find that a formal interview is appropriate. You can see under 7201H8 is where the proceedings for a formal interview are handled. If they find that a formal interview is not appropriate given the circumstances for whatever reason, there is a right to a hearing. It may result in formal or informal sanctions and may result in costs and civil penalties, are subject to special action procedures, which we'll talk about in a little bit, and they are also not confidential. And so let's walk through the different parts of this process. From a timeline perspective, if a formal proceeding is started, there will be a document issued by the board and division staff called a statement of charges and proceedings. This will look very similar to a civil complaint. So for those LDPs that have experience in the civil litigation realm or family law or any other proceeding in front of bankruptcy, in front of the Superior Court, it'll look like a complaint. Very similar. It'll have specific factual allegations laid out. It'll probably have a jurisdictional statement. It'll have a number of things that make it look very similar to a lawsuit. The LDP then has 15 days from receiving that statement of charges and proceedings to answer. And you'll see I note here that Rule 8 of Arizona Rules of Civil Procedure applies. So your general answer, civil answer proceedings are going to apply. So this is in relation to your defenses and timely responding and your waiver and that sort of a thing. Waiver of defenses. I put here also that a response should include a request for hearing and a basis for that request. What I mean by that is you do not, if your complaint has proceeded to this point where a formal proceeding has been initiated, you want to avail yourself of every opportunity to be heard. And a hearing is not a foregone conclusion in this circumstance unless you request it. So I would absolutely say that if you are filing an answer to a statement of charges and proceedings, you should make sure to include a request for hearing and why you're requesting that hearing. A hearing, if requested, will be set within 60 days, and a notice of hearing shall be issued at least 15 days prior to the hearing. So let's talk about the pre-hearing procedures. So again, proceeding along this timeline. So the statement has been issued, what I would refer to as the complaint. Your answer has now been filed. You've requested your hearing, and now we're in this middle time, somewhere between 30 to 60 days from when you file your answer to when the hearing happens. We're in this pre-hearing procedure. Now, the parties can, and I say should be ordered to disclose documents intended to be used at the hearing at least 10 days prior. Again, for those familiar with the civil litigation process, it's going to look a heck of a lot like your disclosure statement that you would put together in a civil lawsuit. Making sure that both sides are fully aware of what the parties intend to use. There should be no surprises. From an evidentiary standpoint, there should be no surprises about what each party is going to present. You have the ability, if this is an issue in your case, you have the ability to request documents for inspection. So if there's some sort of an allegation that pertains to an original document or something of that nature, you can actually request to go see it in person. You can depose people if there's a witness that you believe is essential to your case and they aren't going to be able to be there at the hearing itself. You can actually request to depose that person with a court reporter prior to the hearing. I imagine that this would be a very rare circumstance. The cost associated with it would likely be prohibitive, but in any event, the ability is there. You have the ability to request a deposition for a witness is not available. A witness is not available for the hearing. While you can depose and engage in that sort of discovery, depose witnesses, you do not have the ability to subpoena any documents from third parties. However, a hearing officer may subpoena documents. So what I would say is if there are documents that need to be subpoenaed for your particular situation or your issue, that request should go through the hearing officer, who will then evaluate it and determine whether a Rule 45 subpoena is appropriate. But that ability exists, but only through the hearing officer. And then a pre-hearing conference may be ordered or requested. Again, if you are at this point in the process, not only should you request a hearing, but you should absolutely request a pre-hearing conference. And why do I say that? The reason why I say that is, if at all possible, you want to avoid a complaint proceeding to a hearing. And the reason why I say that is, in almost all circumstances, and I'm sure I could come up with reasons why this may not be true, but in almost all circumstances, you want the opportunity or the ability to resolve this pre-hearing. And a pre-hearing conference is going to be a way to do that, because it is an opportunity where the division staff is going to meet with you in an informal way to discuss what exactly this hearing is going to be about, what exactly is going to be said, what exactly is going to be presented, and whether there's an opportunity to resolve that before all of this needs to take place. There's costs associated with this. You should absolutely have hired a lawyer at this point, so you're incurring costs associated with your legal representation. You've maybe incurred costs developing your case by maybe taking depositions or engaging in some discovery. I mean, I will tell you this, I'm sure, is a time suck for you. And this pre-hearing conference is going to be an opportunity to potentially have this resolved without having to go to a hearing. All right, but let's say we do need to go to a hearing. The parties may represent themselves, and importantly, because this is not in front of an actual judicial body, this is an informal administrative process, you can appear on behalf of your entity. So if you operate your LDP business through an entity, you can appear on behalf of that entity for these purposes. There will be a presentation of evidence. There is an examination and cross-examination of witnesses if necessary. The hearing officer may conduct the hearing in an informal manner without the adherence to rules. And what I basically read that as, I sort of read this the way that that an arbitration in civil cases under the rules of civil procedure, if a case is under $55,000 in controversy in Maricopa County, a civil case will proceed to arbitration, and it is considered, while it sort of feels like a trial because you've got witnesses and documents and all the evidence. It is still an informal process, and the rules basically state that, look, we don't need to worry about the rules of evidence. We don't need to worry about whether procedures are occurring exactly the way the rules of civil procedure say. This is an informal process where it is the goal of this hearing officer to determine what happened, what actually occurred. Did a violation of the rules actually take place? It is not the goal to adhere to strict rules of evidence, which I think is a very good thing. The division will present their evidence first because they effectively are the plaintiff in this circumstance. They also carry the burden to prove by a preponderance of the evidence that this violation that they allege occurred actually happened. And so as long as they can prove by a preponderance of the evidence, which means more likely than not, right, in a weighing of scales, right? If you can imagine scales kind of balancing themselves out, and you have weight of evidence, right? Their weight of evidence needs to simply tip the scales to the slightest degree in their favor that this violation occurred as opposed to not occurred, which is not a high burden, but it is the civil burden that you would need to prove in a civil case. So the hearing takes place. This informal hearing takes place in front of a hearing officer, and so now post-hearing, the hearing officer who heard all the evidence has 30 days to issue a written recommendation and a report and file it with the disciplinary clerk. So it says these findings must include findings of fact and conclusions of law. So all that basically means is, look, I heard the evidence, I listened to all the parties, and I believe, as far as the facts go, these are the facts as they happen, right? Because I had to hear this, that, and the other. There were different versions of the story. This is the version of the story that I believe, and they have to issue that, and they have to say that the division carried the burden of proof, and I believe as a matter of law that they did or did not carry their burden of proof, and the hearing officer will issue their findings. Those findings will also include mitigating and aggravating factors and permissible sanctions. So it basically is an outline for the board as to what they should do next, based on that hearing officer's opinion as to how everything went in the hearing itself. So, and you can see those aggravating or mitigating factors there in H22B. All right, so post-hearing. So we've got this recommendation from the hearing officer. And the hearing officer has either recommended suspension, recommended some sort of disciplinary action, recommended dismissal, some sort of those things. The board will then review the recommendations and either adopt, modify, or remand. Again, just from my own personal experience on these things, and I've had a number of these cases, not for the LDP side, although I have represented in administrative processes for licensed real estate agents, which has a similar process, and also for licensed contractors, which has a similar process for disciplinary action. And I have found that in every circumstance that I've been involved, the board does in fact adopt whatever the recommendations are for the from the hearing officer. I've never had them either modify or remand in any significant way. But it does give them the option to do that. The party who is facing punishment may request a rehearing. The administrative staff or the division staff may also request a rehearing if they felt like some sort of misconduct took place, or we had an issue with the hearing officer. Maybe the hearing officer fell asleep halfway through, and they felt like didn't have the weight of the evidence to consider. They could request a rehearing for whatever reason that might be. Otherwise, the board will take action as above, and will in fact impose a punishment if they felt like the burden was met by the division, or they will dismiss the complaint. If an unjust result occurs, then either party, but most likely this would be the LDP, right? The LDP may appeal, and this is getting to that judicial review that I discussed earlier, may appeal the decision via a special action in the Superior Court. So let me talk briefly about this. We've got about 6 minutes remaining here. I want to talk about judicial review. For those that don't do any civil litigation work or that sort of a thing, a special action in the Superior Court basically is a shortcut where you say, look, there's been an administrative ruling that's taken place here, an administrative ruling that I believe is unjust, and I want an actual judge to take a look at this. Because the hearing officer that makes these recommendations, that person may be an attorney, but they're not a judge in all likelihood. They're just a guy, and if they feel the guy has gotten it wrong, then you have the ability in the face of punishment to have that reviewed by someone else, and the special action procedures, which is part of the Arizona Rules of Civil Procedure, or adopted alongside the Arizona Rules of Civil Procedure, have the ability to basically file. It files essentially as a lawsuit in Superior Court that says, look, we think this guy got it wrong, and we want a judge to take a look at it, and the judge will review it on a standard of abuse of discretion and say, look, we'll take a look at the issues de novo, but we're going to evaluate what the judge actually did. We're not going to retry this thing, but we are going to take a look at what he said, what he did, and whether he followed the rules and did the right thing. And then if you believe that the Superior Court in its review got it wrong, you have the ability to appeal again to the Court of Appeals. And the Court of Appeals will review what the Superior Court said and ruled, and whether they abused their discretion. And then if you feel like the appeals court abused their discretion, you have the ability to appeal your case all the way to the Supreme Court via this track of special action procedure. And so there is a significant amount of judicial review, and I think it gives you a fair level of confidence that if you feel like an unjust process has taken place, you have a path forward that allows disinterested parties, judges, to take a look at what happened to see whether an injustice has taken place. And so I think you can rest assured that that there is enough due process that exists in this in this complaint process, in this disciplinary process, that hopefully the right result will ultimately happen. So, all right, I've got a few other frequently asked questions, that sort of a thing, but I'm sort of at the end of my time, so I'm kind of I'll keep going here for another couple of minutes. But if Don has received any questions or that sort of a thing, he can obviously chime in and let me know, because I'd be more than happy to kind of address those as opposed to go through some additional content that I have here that may or may not be all that interesting or helpful. So Don, I'm going to keep going, but feel free to interject if you've got any questions that have come in via text message and just let me know. You'll need to unmute your mic if you wanna jump in. So otherwise, I'll keep going. A couple of things here. Confidentiality, important to understand that a lot of the documents that are produced by the division staff and that sort of thing are going to remain confidential. While the findings, depending on what happens, the findings may not be confidential. A lot of the documents and stuff, the internal communication, that sort of thing, will remain confidential. And then some questions that I've gotten in the past are, well, I'm facing suspension. I know I may have screwed up, that sort of a thing. What if I, surrender my certification? Or what if I don't ask for renewal? Coming up on renewal, I've got this complaint, I just don't want to deal with it. That sort of a thing. Or what if I abate the issue, right? What if I settle with my clients after they file the complaint and that sort of a thing? And I would say, as to all of those things, generally, I would say, look, I think the board has an interest in having these things resolved peaceably and without a formal process, if possible. And for any of these things, I think this would likely, or potentially at least, result in a dismissal or a shortening of that process. So finally, I'll leave you with recommendations that I have. Take every complaint seriously. I think I've made that point pretty clear over the last hour. Be proactive, be communicative with the division in its process. Do not stick your head in the sand, and do not handle it on your own. Get in touch with someone at our office, get in touch with another lawyer that can handle these sorts of things. Get someone on your side to navigate you through this process, and you'll have the best opportunity to succeed. So that's it. I'm going to turn it back over to Don, and Don, you can let me know.
Brian, I just want to say it was a great presentation, and I just to add to this, don't stick your head in the sand. And as any of you out there that have had to process complaints, had to go through that process, it takes a long time. These things go on and on. It takes a long time, and it can be very stressful. But it'll get done, and the reality is, as scary as it can be, most people come out fine. There's a very short list of people that have ever been suspended or had their certifications revoked. That's obviously a very big deal. It certainly can happen, but it's a rarity, and so don't get too stressed about it. Just do what you need to do. Be honest, forthcoming, and it'll be over eventually. But I don't know I think they have a rule, or they have a rule of thumb that they try to get them done within something like 18 months. So I might be a little off by that, but it takes a long time to get through the complaint process. So any other comments that you have, Brian?
No, I don't think so. I agree wholeheartedly. And I will say, generally speaking, with the exception of a couple of individuals I've had the displeasure of interacting with over there at the division, most people, I think have the LDP's mission and the mission of the Supreme Court at heart, and really just kind of want to resolve these things in a way that allows the LDP to get back to work. So
absolutely, I don't have any questions for you, and so I'll just thank you, Brian, as always. We at AIP, and I think I speak for most everybody that has attended your presentations, your webinars. We appreciate you so much, your whole law firm, for all that you do for our industry and all the help that you give. And so thank you very much. Oh, well, hold on. I just got a question in. So Brian, you're still there? All right. So the question is, during the process, are you still able to do business, or do you have to stop? So once
yeah,
you,
yeah, that's a good question. So so the answer is that unless the board, and I covered it really briefly, so you probably you would have, if you blinked, you may have missed it, but unless the board seeks an emergency suspension after an initial review and that sort of a thing, there is a method by which the board and the division staff can seek immediate suspension of a license. Unless the board goes that way, and that would be, like I said, in a really extreme circumstance, then no, there is no disruption of your business other than the time you're spending dealing with it. Your business can continue to operate as normal until, and this comes back to the due process issue, right? Where you are innocent until proven guilty. Just because someone's alleged something against you doesn't mean it's true until there's been a hearing or a determination by the board, as the case may be. So yes, the short answer is you can continue to do business until such time as your license is suspended on an emergency circumstance, or there's been a final determination by the board that there's that a suspension is necessary, and that'll be after a formal hearing and any appeals that you may seek. So so that's the answer.
okay. All right, well, again, thank you very much, Brian. Those were all the questions that we had, and we're ready to move on to our next presentation. But before I do that, actually, I want to get into, I'm going to hold up our first word of the day. And as I mentioned at the beginning, we're going to have 3 words. We're going to have 1 word right now. And then, and Jim, if you're listening, I haven't mentioned this to you, but somewhere around an hour into your presentation, I'd like to have another word that we're going to put up. And so, Jim, can you hear me? You can shake your head yes or? Okay, good. All right. So I'm going to hold up the first word of the day, which is, see if I can get this in front of the camera, spoon. So the first word of the day is spoon. And so what you want to do is you want to write this word down and just make sure at the end of the seminar, sometime in the few days afterwards, you're going to need to email me each of these words, each of the 3 words, and then I will respond in kind by sending you your certificate of completion for this class. So on to the next presentation. I'd like to welcome Jim Tewalt. And Jim, I'm gonna put you live in just a second. Jim is a certified financial planner, and he's a certified legal document preparer for many years. And Jim's going to give us a presentation about living trusts and related issues. So Jim is going live in just a second. There he is. All right, Jim, you are live. And Jim, let us know if you need any help with your putting up your PowerPoint. Oh, Jim, okay. Jim, you need to unmute, please, on your screen. Jim, we can't hear you. You need to unmute.
All right, am I unmuted?
You're unmuted. So let us know if you need any help with your putting up your PowerPoint. But you're ready to go. You're on live. Everyone can see your answer face.
Can you see the PowerPoint?
I will put that up in just a second. Okay, we can all see it.
The technology is the biggest challenge. Excuse me.
That's it.
All right, Jim, you're all set to go.
Do I get to see me too here or no?
No.
Maybe not.
No.
It's not all that important.
PowerPoint.
Okay, great. Well, let's get started. And were they going to get a chance to take a break or no? No break?
Yeah, whenever you're ready to take a break, you let me know, and that's when I'm going to do the second word of the day. So I'm anticipating about an hour.
If you could flag me, Don, at about the 11 o'clock time, that would be good. Because sometimes I get rolling and then I just kind of lose it. So
I will chime in.
All right,
Ready to
so
go?
let's get started. We're going to be talking about nuts and bolts of living trusts, and some of the information that I'm going to give you is going to be information I've given you before, but on the things that we've talked about before, I'm going to try to move through them quickly so that we can get into the topics I want to discuss, which is how to fund a living trust, and then also talking a little bit about a topic that Carol Aragon Montgomery brought up at her last presentation, which was business succession planning. So we'll talk about that a little bit as well. So I always have three goals when we do this. The number one goal is that we all learn something. I often learn a lot just by doing the presentation. Usually I learn because I'm doing it at the Sheraton and there's 50 people in the room, and if I say something that's incorrect, I get corrected very quickly, and I love that. So number one goal is we learn something. Number two goal is that we get inspired or we come away with something that we can use in our businesses. The last time that that I was at the Sheraton, there was a couple of comments that were made by presenters on topics that I normally wouldn't have a great deal of interest in, but the comments were really relevant to my business. I wrote them down and came back to the office and implemented them. So that's important too, that we get inspired. And then the third objective, which is probably the first objective, is that we stay awake. It's hard to achieve objectives number 1 and 2 if you don't get number 3 done. And so the biggest thing here would be that I stay awake for this presentation. So the screen shows that I've got my contact information up there, and what I would like you to do is that if you'd like any of the information that I'm going to share, send me an email after the presentation. I'd be happy to send you the presentation itself, and I've got a couple of exhibits as well that I'm happy to share with you. So my background is that I'm a certified financial planner and a certified legal document preparer. I'm a licensed insurance agent for life and health insurance now in Arizona and a few other states. But I started my career as a life insurance agent, and then I got involved in the employee benefits business. I actually went to work for a company called Marsh & McLennan. And then following that, I had my own agency for a while and got hired by a gentleman that owned a property and casualty insurance agency. He was facing open heart surgery. He wanted somebody in his office that could interact between his office and himself during the surgery. And so I went to work with him. And I'm saying all of this because I want you to know that I have a background in a lot of different areas. When I got into the property and casualty insurance business, I could hardly spell auto or homeowners insurance. Or business insurance for that matter. I was really out of my element, but there was a couple gals in the office that actually knew a lot more than I did. They were not afraid to let me know every day how much I did not know. And in that kind of an environment, you are either going to sink or swim. And I opted for swim. So I began to read contracts, actually. I read the insurance policies, and I developed a reputation for being able to get claims paid because I did read the policies. So I could tell you stories about that, but right now I really want to get in the presentation. So let's talk a little bit about estate planning and living trusts. So first of all, as just business owners, we have a great opportunity. There's currently 7.3 million people in Arizona, of which about 5.5 million are adults. A little over 1,150,000 are seniors. And then if that's not enough people for you to consider working with, we have about 200 people a day moving into Phoenix. So virtually all of them need some kind of an estate planning, including you. And if you have clients, if you're doing work of a different type, and I know that all of you have different specialties, but basically all of your clients are going to need some kind of an estate plan. It might be simple, it might be complex, but everybody has a need, including all of us that serve as legal document preparers. I Googled the average cost of a living trust in Phoenix, and Average attorney cost for a living trust about $1,000 in Phoenix currently, and about $1,500 for a family. So not into price setting or anything like that, but just give you an idea what the costs are and what kind of a compensation you could be looking at. So I just read an article in Kiplinger's, and it was not why you may not lead a living trust. It was actually why you don't need a living trust. And I read the article, and basically what the article, the writer said was that a living trust is probably going to cost you $1,500 to $2,000. A simple will might cost you $300. You really don't need a trust. Well, when it comes to avoiding probate, the writer of the article is probably correct. There's a lot of ways of avoiding probate, and I've got a couple of them on the screen here. If you have bank accounts, you can do what's called a POD, or payable on death, to the beneficiaries, and that will result in the accounts being, the balances being distributed directly to the beneficiaries without going through the probate process. If you have investment accounts at Merrill Lynch or some other firm, you can put what's called a TOD designation on it, or a transfer on death designation, which would get those accounts transferred to the beneficiaries, again, without the probate process. And of course, if you have life insurance or IRAs or 401ks or annuities, all of those types of accounts automatically transfer to beneficiaries by virtue of a beneficiary designation without going through probate. So probate is really not the big issue when it comes to estate planning anymore, in my opinion. And of course, I didn't go through the streamlined probate, but you all know if the account is, or if the probatable estate is small enough, you can transfer by affidavit, or you can do a streamlined or informal probate in Arizona. If the account value is under $75,000, I believe, without real estate, and under $100,000 with real estate. And again, when you look at the value of the real estate, you have to look at what the value is, but also what's owed, because if you subtract out the mortgage, you might come within the guidelines. So all of that to say that probate is really not the big issue when it comes to estate planning. One of the things that motivated me, actually there was a couple things, but back in when I lived in Wisconsin, and in all fairness to attorneys, this was 36 years ago, so a lot has happened since then. But I read a book by a gentleman from Minnesota. A guy's name was Carl Foster. He wrote a book. It was called How to Disinherit Your Attorney and Save the Family Farm. And the reason he wrote the book is that during that period of time, very few people had revocable living trusts. Most estates were settled via the probate process. And that could be very expensive, it could be time consuming. And if you know anything about probates, you know that they can be contested. And if you know anything about human nature, you know that some people are great and some people are just out and out stinkers. And so you have a process there that was very susceptible to all of the bad things that could happen. Take a lot of time, cost a lot of money, and give people an opportunity to bollocks up the process. All of it not good. So, but back in Wisconsin, we did not have a certified legal document preparer program. So I belonged to a group of guys that we called the Friday Morning Choir Boys. And we were a couple of attorneys, some financial guys, life insurance people, and we would drive a half an hour. I would drive a half an hour in the winter over icy roads to get to our favorite breakfast haunt. And on Friday mornings, we would talk about estate planning and talk about financial planning and so forth. And one of the things that one of the attorneys talked about, and his name was Bob Alexander, and Bob used to say this: most people that come into my office want just a simple will. They just don't want to spend a lot of money. They just want something that's very, very simple. And he said, when I talked to him about doing a living trust, they always perceive it as kind of an upsell, and I get a lot of resistance. He said, you guys can talk to people about the advantages of a living trust, and that makes my job just so much easier. So again, back in Wisconsin, we could not prepare documents, but I did learn about trusts, and because I thought they were really beneficial to my clients, I did talk about the advantages of avoiding probate and all the things that a trust could do, and then referred the people happily to Bob Alexander, and of course he was happy about that as well. When I got to Arizona, I found that, and I got out here in 1986, at that particular time, Arizona had an unauthorized practice of law statute, but it had sunsetted. So this was the wild, wild west. And I actually ran into some attorneys out here that did not like living trusts, and they actually would take someone who had a living trust, take all of the assets out of the trust, and put it through probate. So I'm not sure about the wisdom of that. I got into a couple of discussions with those attorneys, and finally I just walked away scratching my head. So for me, when I found that I could prepare documents, I started doing that because I love my clients, and I knew that there were some advantages in having your estate in a revocable living trust. And back at that time, they were far more simple than they are now. And I just could not find anybody that would do the job for my clients and do it on a reasonable basis. So I just began to do it. I was really motivated by wanting to help my clients with the probate process or with the estate planning process. I actually had a client, and you know, when we're talking about this, I'm going to hold this up and hopefully you can see it. This is an estate planning portfolio that we do. I'm just going to call this the, you know, for want of a better term, the magic words, because, you know, today we live in a very litigious society. Nobody does anything, no financial institution does anything unless they are pretty certain that they're not going to have some liability in it. So everything is done in writing these days, and we're gonna touch on that a little bit further in the presentation. But I actually had a client, because what I want to do is I want to get this beyond just you know, talking about facts and figures. I really want you to see this with your clientele as this is all about the people that you work with and what their goals and dreams are and what their desires are for their families, and how you can help them achieve those desires by putting in writing what they want to do. And that's basically what we're doing. We're scriveners, we're scribes, if you want to call it that. Our job is to put in writing the desires of our clients, especially in the estate planning area. I know in other areas it's a little different, but I actually had a client, the gentleman passed away in 1992, that was Ted, and they had a revocable living trust. And at that time, I did not prepare the documents. They actually had an attorney out in Sun City that prepared their documents for them. And they actually asked me to take a look at them one time, and again, I could not give legal advice or anything, but I noticed that there were some items missing that they might want to have in there. And so I gave them a list of those items. They went back to the attorney put them in and did their documents. Well, in 1992, Ted passed away. 24 years later, in 2016, his wife passed away. And during that period of time, she was taken care of by the trust that he had set up for her. Back at that period of time, the federal estate tax limitations were a lot smaller than they were today, so they had what's called an AV trust. So there was a trust that belonged to Ted that was set up for Helen's benefit. And of course, Helen had a trust that was set up for Ted's benefit, but he passed away first. So his trust took care of her for the next 24 years. And then when she passed away in 2016, imagine the surprise of his heirs, his side of the family, when 24 years after his passing, they received distributions from his trust. I'll tell you, I was involved in that process, and I was a very popular guy for a while there. The kids and the grandkids had absolutely no idea 24 years later that they were going to receive the sums of money that they received. So I want to just make this personal. I actually did a trust for a grandma in Sun City years ago. When she passed away, her daughter and her daughter's husband came out to Arizona and to settle the estate. And about 2 days into the settling of the estate, I got a call from the daughter. And I said, what's the problem? And she said, well, can I come in and see you? And I said, well, I guess so, sure. So they came in, and she said the problem that they were having is that the grandchildren were fighting over grandma's coin and Kachina doll collection. So they asked me what to do. And again, I can't give legal advice, but what I suggested was, I want you to read 2 paragraphs in the trust to the kids and the grandkids. One of them is the paragraph where grandma appointed you as the trustee to carry out her wishes. And the other one is the paragraph that says, if you complain too much, you could be disinherited. So she read those paragraphs, and then she came back a couple days later, and she made a comment that I've never forgotten. And the comment was this. She said, after I read those 2 paragraphs, you could have heard a pin drop in the carpeting. So what I'm saying here is that when we're drafting these documents, it's more than just putting words on a paper. You're transforming lives here. You're enabling people to do what they want to do, and you're enabling that to happen in a very inexpensive and very efficient manner. So let's move on quickly here, and some of the stuff we've done before, so I'm just going to kind of breeze through it rapidly. First of all, what is your estate? Well, it's everything you own, basically, all of your real estate vehicles, watercraft, your retirement plans, your business, your investments, any mineral rights you might have, timeshares, even your life insurance is part of your estate. So what is an estate plan? Well, it's a written personal plan to manage your estate and affairs while you are living, if you're unable to do so yourself, and also to transfer your money, assets, and insurance proceeds to your heirs efficiently and economically at your death. Why a written plan? Well, again, as I mentioned before, we live in a litigious society. Nobody does nothing, and I know that's very bad English, but if you're a financial institution, you are not going to do anything unless there's something in writing that gives you permission to do it. Otherwise, you pretty much know that somebody's going to be unhappy, somebody is going to sue, and no financial institution wants to be in that position. So really, we're talking about 2 things here: how to transfer my stuff when I die, and how to manage my stuff while I'm alive, or have it managed for me if I'm incapacitated. That's the basics here. So there are when it comes to estate planning. Probate is one, and I tell people today that probate is really pretty easily avoided. There's just so many ways to do that with the POD, the beneficiary estate, beneficiary deed for transferring real estate. Am I still there?
Jim, are you having a problem?
His internet is not working.
What?
His internet is not working.
This internet?
His.
Oh, his. Should I put me up? Oh, I think you're on again, Jim. Sorry
Okay,
about that.
great. Okay. Maybe one of the participants got tired of hearing me talking. Are we back? I can't hear you, Don.
I'm sorry. Yes, we are back.
Okay, good. I can hear you now. All right. So let's jump back in. Probate is pretty easy to avoid. Then there's conservatorship, and conservatorship basically, I think I've got a definition here, the court supervised process where a judge appoints a responsible person or organization called the conservator to care for another adult called the conservatee who cannot care for himself or herself or manage his or her own financial affairs. So let me get this down to where you live. Let's say that you are married and you are on your way to sell your home, and on your way to the title company office, the husband has a stroke. And now he is unable to speak, unable to sign his name. You get to the closing, but that closing is not going to happen. And the reason it's not going to happen is that one of the people involved cannot sign their name. So when you have that kind of a situation, absent documents prepared in advance, you could wind up going to the courts to set up a conservatorship. You could actually be in a situation as one of the spouses where you would have to work through the courts to manage your own finances. I can't think of anything that would be more frustrating. It's time consuming. There's fees, attorney fees, CPA fees. There's a yearly court report. There's record keeping requirements. And oftentimes you're in a situation where if you want to make a significant financial decision, you may have to get the court's permission to do it. So all of these things can be avoided very easily. Then there's a control issue. The control issue is what happens beyond the grave. If you've worked hard to build an estate, obviously you could transfer it to your beneficiaries by virtue of a simple will. You could give them complete control of everything, but you may not want to do that for a number of reasons. First of all, the beneficiaries, if they're minors, they cannot receive the estate assets until they're at least age 18. If they're special needs beneficiaries, and they're minors as well, obviously they could not receive the inheritance because of just being minors. But if they're special needs beneficiaries, getting an inheritance from you may actually disrupt benefits that they're eligible for. So that could be bad. You may have beneficiaries that are into substance abusers. You may have beneficiaries that are spendthrifts, don't know how to handle money, or you may want to incentivize or have certain carrot provisions. I was a UCLA grad. If you go to UCLA, I'll pay for your entire education. That would be like a carrot provision. Well, that's hard to put a carrot provision. I mean, it could be done in a will, but it's hard to enforce it once you give the person the money. But in a trust, that could very easily be done. So. We talked about this a little bit, the capability of beneficiaries to handle their financial affairs. This is a big one, the creditor protection. I've read online articles from a number of attorneys that talk about the importance, if you're going to do a trust, the importance of retaining the assets in the trust for the beneficiaries because they get creditor protection. When you set up a revocable living trust for yourself, there is no creditor protection because the trust is kind of like an alter ego. It's an extension of yourself. No creditor protection for you. But once your estate passes to your beneficiaries, if that inheritance is passed in the trust, then they do get creditor protection. So if they get into an auto accident, it could protect the assets from auto accident settlement, or if they have creditors from those creditors, or If there's a toxic spouse in an unstable marriage, winds up in divorce, you have a toxic spouse. Assets kept in the trust could be kept out of that kind of a situation as well. And then, of course, you can do unusual distributions. When I started as a legal document preparer, I started because I wanted to give my clients access to inexpensive documents for their simple situations. What has happened over time is we rarely get the simple situations anymore. No longer Susie and Sally each get 50% of the estate outright. End of story. We get to more complex stuff where there's a second marriage and they both have kids and there's a business involved, and one of the children wants the business, wants to be able to run it, but they want to make sure that all of the children get some benefit out of the business. So we get very complex situations. And when that happens, again, our job is just to take the complex and make it as simple as possible, make it as understandable as possible, because you're going to have, after somebody passes away or after somebody is incapacitated, you are going to have a successor trustee here who is probably a family member, who is going to be able to, or is going to want to be able to understand what the person that created the trust wants to happen. So, and then there's the privacy thing. A probate is a matter of public record. Living trusts are a private matter, and oftentimes they don't even, well, they don't wind up as a matter of public record. So the fourth issue, there's 4 issues. One of them was probate, then control, conservatorship, and the fourth one is estate taxes. Now today, currently, the federal estate tax exemption is $11.58 million personally, and double that, $23.16 million for couples. So in other words, if you were a couple and you want to leave your estate to your heirs, to your children or other heirs, you can leave up to $23.16 million without incurring any federal estate taxes. Now, there might be state estate taxes in some states. There are none in Arizona at this particular point, but there could be federal estate taxes. So these will sunset in the year 2016 by law now, which, but that may or may not happen. A lot depends, I think, on how much tax money the government may need at that time, and based on what we're doing currently, who knows what will happen. So, but they're due to sunset in 2026, and when they do, they will come back to the $5 million personal exemption, $10 million couples exemption. Now, I have a lot more slides I could put in here, but in the interest of time, I don't want to do that. So what I'm going to say is that if you're leaving assets to a spouse, there is no exemption amount. You can leave as much as you want to your spouse. If they're a U.S. citizen, it could be $1 million, $1 billion, all the world's wealth. But when it comes to leaving assets to non-charitable, non-spouse heirs, which means your children or your next door neighbor or whoever you want to leave the money to, there you have that that $11 billion exemption currently, and $23 million exemption for a couple, and that will go in the year 26 back automatically if the government does nothing to 5 million personal, 10 million couples. So what does that mean? What opportunity does that present today? Well, if you look at a lot of the trusts that have been done out there, a lot of people did what's called A/B trust planning. In other words, where the trust was at the death of the first spouse was broken down into an A trust and a B trust. An A trust for the person that's still alive and above ground, and a B trust for the person who is buried and below ground. So, but that type of planning for a lot of people who don't have $5 million or, personally, or $10 million as a couple, they don't need that type of language in the documents anymore. So a lot of my attorney friends are going to people that have those documents and doing just a simple probate avoidance trust, taking away the complex language that is not needed and taking away the necessity to break the estate down into two pieces when the first spouse dies. Now, there may be some reasons for continuing to do that. Second marriage is one of them. But what this does is it gives us an opportunity for doing some reinstatement. So I'm going to go through these slides very quickly. Actually, a couple of years ago, about 60% of Americans had done no planning. We're making a dent. We are improving that situation. These days, it's about 30 to 50% of Americans have done nothing. We're going to pass through this. We've covered this already. So the great solution is the revocable living trust. And a trust is really nothing more than an agreement created during the life of a creator or grantor that grants legal possession and control of funds or assets to another person or entity, which is the trustee, who holds such funds and assets for the disposition to a beneficiary or beneficiaries according to written instructions. Now, if I read that to most of my clients, that's way too complex for them. So what I tell them is that a revocable living trust is kind of like a box. If you put your assets into the box protects those assets from certain things like probate and conservatorship, and gives you the chance to provide more controls over how you're going to leave your estate to your kids and other beneficiaries, and it can help mitigate federal state taxes. So you can make this thing as complex or as simple as you want. A revocable living trust by nature, by name, can be revoked, amended, restated. It's the alter ego of the grantor while the grantor is alive and not incapacitated, but it becomes its own tax-paying entity at death. So while the person who set up the trust is alive, it's changeable. Once that person is either incapacitated or deceased, it's etched in stone at that point. Revocable living trust documents. When I first started in the business, a lot of attorneys would do a trust, and then if you wanted, they would do a will as well, and maybe powers of attorney. What happened when legal document preparers started getting involved, and actually even prior to that, we started doing these things as a portfolio. And I tell clients, I don't know what documents that you're going to need in the future. So what we do is we do a portfolio that includes virtually all of the documents that you would probably need, so that if a situation comes up that requires a specific need, we should have a document in the portfolio to address that need. So in a revocable living trust portfolio, you're going to find a living trust, obviously, certification of trust, which I call like the Reader's Digest condensed version of the trust. It gives you essential information that a financial institution might need to know, but it doesn't give all the details of who's going to get the assets and how they're going to receive them and so forth. There's a declaration of trust that basically states that the person is setting up the trust really wants all of their assets to be in that trust. There's a marital property agreement between spouses, again, stating that all of their property, either sold and separate or jointly owned property, they really want it to be in the trust. There's a tangible personal property agreement that allows you to include vehicles, all-terrain vehicles, trailers, golf carts, watercraft, gold and silver, clothing, all of your personal property. Basically just states that all of those things are in the trust. And then there's a last will and testament, what's called a pour-over will, that basically takes any assets that are not in the trust, puts them through probate if necessary, and kind of pours them over into the living trust. There's durable financial powers of attorney, healthcare powers of attorney, living will, mental health care powers of attorney. personal property transfer form, sole and separate property lists, final instructions. Do you want a traditional funeral with the El Camino and the flowers in the back, or do you want to be cremated? Where do you want your cremains put? Packer, Lambeau Field, if you're a Packer fan like I am. That's probably not going to happen, but maybe you want your remains scattered in the middle of the ocean somewhere. Whatever it is, you can state all of your wishes in that document. And what I have found over the years is people do things for very emotional reasons. They will do estate planning sometimes because, and I've had this where there was a former spouse or an ex-spouse, and maybe the divorce situation was very toxic, very emotional. And even though the divorce decree really separates the former spouse from any right to the estate of the divorced spouse, what I find is a lot of people like it when we disinherit the former spouse in the trust. And I know that that's overkill, but I've had clients tell me, you will not believe how devious that guy or that gal is. If there's some kind of a way that they can wiggle their way in, they will do it. Yeah, I would love to have them formally disinherited in the trust. Call me devious if you want, but if that's what it takes to get somebody to do their estate planning, I'm probably not above that type of thing. I've seen people die with estate plans, written estate plans, and without them. I've seen people get disabled with and without documents. And I will tell you, in every case that I've seen, it's always better to have the documents. So whatever it takes to get people to do that planning, like I say, I'm not above doing what it takes. I guess I won't go any further than that. So there are different types of trusts for different kinds of situations, and we could dig into this, and maybe in the future we will, but today a simple probate avoidance trust will handle it for most people. You can do disclaimer trusts that can help with Medicaid planning, and I actually did one a couple of years ago where we had a second marriage situation, and we actually, we thought that the guy was going to he had all the medical problems, and the wife was healthy as the proverbial horse. So we set up the trust where it had disclaimer provisions where he could disclaim the trust and thus be qualified for veterans benefits and all tax benefits after the 5-year or 60-month waiting period. Well, it actually worked out the other way. He died first, and then when he died, she did a disclaimer of her right to the trust assets. And she went into a nursing home, and she was in there for 5 years. And at the end of the 5 years, she wound up being up in Wyoming. And at the end of the 5 years, she qualified for the Wyoming plan benefits by virtue of the fact that she had passed the 60-month eligibility period, and she had disclaimed the assets. And they started the 60 months from the date that she disclaimed those assets. But the trust still had wording in there that said that the trust treated her like a special needs beneficiary and allowed the trust assets to be used to supplement, and only to supplement, her lifestyle. So she could still get her hair done. She liked to buy things on Amazon, and she was able to do those kinds of things and use the trust benefits for that purpose, but still not be disqualified for Medicaid planning. So there's AB trusts. They can be used where there's children from former marriages involved. There is a trust called the Intentionally Defective Marital Deduction Trust, which sounds like a mouthful of words, but it actually is very helpful in situations where there are second marriages and you want to be able to give the current spouse some rights to assets, but also to protect the children from the first marriage from the gigolo or the bimbo that might want to come in and steal the estate away from the kids.
Can I put so I can attend the question that Karen asked? Can I put some any name like what can I put like change?
Say that again, please. Okay.
The question, some people record their certification of trust with the county, but what if the grantors make amendments to that trust and don't re-record? What kind of legal issues may arise, if any?
Tough questions like that are unfair. Can you repeat the question, please? Repeat the question, please.
The question is, I know some people record their certification of trust with the county recorder, but what if the grantors make amendments to that trust and don't re-record? What kind of legal issues may arise, if any?
Well, I think it would, and again, I'm not an attorney, so I'm going to kind of defer there, but I think a lot would depend on what the certification of trust said. If you amended an area that was not discussed in the certification of trust, it could be no harm, no foul. If you amended trustees, as an example, then I think if you're going to file those or record those with the county recorder, and I have never done that in my career. In fact, the reason I've not done it is that most people do a revocable living trust for privacy reasons. They do not want that document to be a matter of public record. So we've never recorded them. But if you did make some changes in the trust, as an example, the trustees, and that will show up in the certification of trust, then I think you better go ahead and record the new certification as well.
Yeah, I don't know. Again, I'm not an attorney either, but I don't know that there would be any consequence to the fact that it was subsequently changed, because you're not required to record that in the first place. I have another question as well.
All it would do by just re-recording is to reduce confusion.
Exactly. But yeah, most is one of privacy too. Most people just want to keep that private.
Right.
So the next question is, if you have a trust and file for bankruptcy on your business, for example, because of Corona, what are the, are there any, is there any impact due to that, or what are the considerations?
Well, again, a trust for you, the person that created it, a living trust is basically an alter ego. It's an extension of yourself, and it doesn't give you any bankruptcy protection. The only protections that you might have there would be in your business, depending on if your business is set up as a corporation or as a limited liability company. You might be able to protect your personal assets from your business assets, depending on the situation. But the trust itself is not going to offer any protections. There's no advantage there to the trust. The trust job really is fourfold. Number one, avoid probate. Number two, avoid conservatorship. Number three, give you the chance to put more controlling language, kind of control the beneficiary from the grave, so to speak. And number four, to reduce the impact of federal estate taxes. But even in the federal estate tax area today, there's such a thing as portability. It used to be that each person had their individual estate tax exemption. Now you can transfer them between spouses. So the reason for doing the AB trust planning for reasons of avoiding federal estate tax purposes are pretty much gone. So, but in terms of just the being sued, the bankruptcy situation, I don't see any protection in the trust there.
Okay, thank you. Are you going to talk about dynasty trusts later?
I am.
Okay, I'll leave that for later.
Okay, actually, next page. So in the, if you left your estate by a simple will, it's going to be an outright distribution. You could wind up with a probate situation, probably would wind up with a probate situation. People can contest and so forth. People are people, and they're going to contest either way. So, but there is language in trust today called trust protector language. And you can either name a trust protector or you can put the language in there. But basically, under the Uniform Trust Code, there is an opportunity in there for situations where beneficiaries get out of sorts with the trustees, as an example, to resolve situations without going to court. And that's what you want to do. You can name a trust protector, or you can put language in the document that says if there is a confusion amongst the trustees, as an example, or if the beneficiaries do not like what the trustees are doing, there is a mediation process there with the trust protector to get things resolved without having to go to court to do it. Conduit IRA language is basically a language that began to appear in trusts after 2006. And what it does is allows you to name a trust as the beneficiary of an IRA and to have language in that trust that allows the trust to be the beneficiary, yet to hold those IRA accounts for the benefit of certain declared beneficiaries, usually the children. So, institutions that hold IRAs like Schwab and others, they're looking for certain language in there that the trustee has to be able to demonstrate in order to make the do the administrative things that the trustees would want to do to handle the IRA. So that type of language is in there. Dynasty trust provisions is basically what we talked about before. If you leave your assets outright, in many trusts have that language in there where the person that owns the estate dies, last spouse dies, leaves their trust monies and so forth to the beneficiaries, and oftentimes it's done outright. If it's done outright, there is no creditor protection, and that's the biggie today. If you go on not YouTube, but if you go on Google and Google Dynasty Trust Provisions, there's a number of articles written by attorneys that really come out pretty strong to say that virtually no beneficiary should get an outright distribution if it's done in trust, that the creditor protection in the trust is really worthwhile. And so using the Dynasty Trust Provisions basically allows you to leave assets to your children, and those assets are going to go automatically to their children and to their children's children's children. In this state, there's what's called a law of perpetuities, where you can only keep assets in trust for so long. In the state of Arizona, it's 500 years after the death of the last named beneficiary or class of beneficiaries. So you can actually keep assets in trust for a long time for the benefit of your children and your children's children, and grant them that creditor protection, which I think is a real big deal. Does that answer the question?
Can I ask a question about that? Can I ask a question about that, Jim?
Yes, go ahead.
Okay, just I wanted to take it a step further. Could you explain? I think one thing that might be off-putting to some people about a dynasty trust is it appears that it has to stay in the trust forever, for 500 years. Could you speak about it from a more practical perspective? In other words, the fact that, who really manages the Dynasty Trust, and the fact that, the trustees can really take all their money, or the beneficiaries, if they're the trustees, can really take all their assets whenever they want to.
Right. Yeah, the practicality is, in most cases, the children are named as beneficiaries. Oftentimes, there will be a trustee named until the children reach a certain age, or if the children, if it's a special needs child, of course, then the trustee will always be in control of that portion of the trust. But from a practical standpoint, the kids are often named as beneficiaries, and they have their assets in the Dynasty Trust. But from a practical standpoint, the kids could take those assets out of the trust if they want to and just spend them. There's no trust police that are going to be watching the kids to see if they leave the assets in the trust or take them out of the trust. So that's purely up to them. I did a trust a few years ago for Dad, and when he passed, we had done the Dynasty Trust provisions, and the son had a business. He was in California, and the daughter had a business here in Arizona. And in both cases, they wanted to have their portion of the estate kept in that trust because they knew they had the creditor protection. So, and I just simply told them that, according to the trust provisions, you can leave it in there. It's going to automatically go to your children if you wanted to. But from a practical standpoint, the control is still there for the beneficiaries to take those assets out of the trust if they want to. So I just like it because it gives opportunities to beneficiaries to protect those assets if they want to. If they don't want to, they're not obligated to do so. So it just gives them options. You can do pet trust provisions. I'm a horse person. Anybody that has horses has just kind of a crazy relationship with their animals. So we have done pet trusts where people have left. I had a guy leave $100,000 to his dog in a pet trust and set up specific trustees to manage that money, and then people to take care of the dog, and named even the veterinarian that would treat the dog. And so again, I've never loved any of my horses that much, but I have had people that do it. And if this is what it takes people to do their estate planning because they love their horse, I'm great with that. I just want to see them have an estate plan in place, written, because I know that when they do pass or if they become incapacitated, those trust documents are going to be very important at that point. There is firearms trusts. There are a certain segment of the people that have what's called Class 2 firearms. That could be bazookas, machine guns, grenades, things like that. The story is told that if you passed away and your wife sold your bazooka at a yard sale, because she never liked that thing anyhow, never loved having it in the house, she could actually go to jail. It's a felony to sell that kind of a firearm. So you can have these things set up in trust, and if you have the licensing or the certification to be able to own those kinds of firearms, you can set up a trust where you can transfer those firearms to beneficiaries, to other people who also have that certification. So again, this is very important to certain people, and I think if just being able to do those kinds of things oftentimes gets you in a position where you can do the other planning as well. IRA trusts, important today. It's the conduit IRA language. IRA trusts are important today because if you have a 401k at work and you get sued under ERISA law, that 401k is protected from bankruptcies. An IRA is not, but an IRA inside of a conduit IRA language in a trust is protected from lawsuits for the beneficiaries. Then there's reverse mortgage language. So there's just a lot of things in here that you can do in a trust that are just far more robust than what you can do in a simple will. And as you talk to your clients about this, you're going to, if you just talk about what things can happen, what can be done in a trust, you're going to probably find an area that that's important to your clients. So it's 11 o'clock. It's time for
Yes.
the word of the day.
It is time for the word of the day. 1 second, let me put myself on live here for a minute. Okay, I think I'm getting it here. All right, so it's 11 o'clock time for the next day, and let me see if I can hold that up here correctly. So the word of the day, and please write this down, is tree. So write this down along with the word I've already given, and there'll be one more at the end of the webinar. So the word is tree. So hopefully everybody has that, and then we will move on towards the end of the seminar. Remember, there'll be one more word, and at the end of the webinar, I'll talk about how you send that information to me to get your certificate, and also I'll talk about a couple other things at the very end. But so, Jim, are you ready to proceed?
Okay, yes. So when does a revocable living trust become irrevocable? Well, that happens when the person that created it passes away, or when that person becomes incapacitated. And at that point, the revocable trust gets its own tax identification number from the IRS, and it becomes its own tax-paying entity. So I have a question here. Why name your trust as primary beneficiary of your IRA? Well, the only reason you would do that if you had a spouse, if you were single, no spouse, or if you have a spouse that maybe was incapacitated, then you could name your trust as primary beneficiary. Normally, we don't do that. I'm going to skip through some of this because I really want to get into. Well, let's just talk about this. So when you're talking to clients about a trust. And again, this may not be your primary area of business. Maybe it's something that you'd like to do. Maybe it's something that you would rather dish off, not a problem. But if it's something you would like to do and you've never done one, just remember, everybody was at the point sometime where they had never done one, even me. So if you feel like you have a situation with a client that you think a trust might be something that they would want to do, you've talked to them about the advantages and so forth, and they decide they want to do one, you know, we're a group, we're here for each other. If you had a situation like that, you'd never done one before, and you want to do one, give me a call. You know, I'm happy to walk you through it. We all have to start at some point, but basically what a trust will do is help you to manage your finances while alive if you're incapacitated, transfer the estate efficiently and economically at death, and control those distributions beyond the grave. That's basically the main things that a trust can do. And a lot of people are looking for that. So I'm going to throw in a plug here for Dennis Fox at ForTrust Software. When I first started, I had my own software that I found, well, let me just put it this way. Plagiarism is when you steal from one person. Research is when you steal from a number of different sources. So in the very beginning, I didn't plagiarize, but I did steal from a number of different sources, created my own software. But as things got more complex, I tried a couple of different programs. I finally found the ForTrust software. I love it. Dennis Fox is a retired attorney. He keeps that program up to date. Yeah, they have glitches once in a while, everybody does, but it's a great program. So I'm throwing in a plug for ForTrust software. So I've got a data gathering form that if you have never done a trust before, or if you're just curious as to what somebody else's data gathering form might look like, I'll be happy to send it to you. So let's talk about funding, because unless you fund the trust, you really haven't done anything here. Let's see if I can do this. Okay. So I'm going to tell you a quick story. Years ago, I had a life insurance guy that referred me to one of his clients, an elderly lady who lived downtown in a assisted living facility. And he said, I would like you to do a trust for her. And so I talked to her and we got the trust all created, drafted and so forth. And then we went down to visit her to get the documents signed. And on the way down there, he told me, this lady will not, she's very secretive about what she owns, what she has, and she won't tell you everything that she has, because I had told him about the importance of getting the trust funded. And I said, well, I will bet you lunch that she will tell me everything. And he said, you're on. So we got down there and we sat in her room and we signed all the documents. And then I said to her, now, I have to stress to you, ma'am, that the only things that in your property that are going to be protected are the things that you put into the trust. So if you have anything else that you have not told me about, it will not be protected by your trust. And she said, well, I happen to have $40,000 in cash between my mattress and my box spring. So I got lunch out of that deal. So that was the only thing she hadn't told him about. But basically, it's important if you're going to do a revocable living trust to make sure that all of those assets get either title in the name of the trust, or the trust is named as the primary or contingent beneficiary. And there is some skill to this, and it's my training as a certified legal document preparer, as a life insurance agent, that gives me some background on how to do some of these things. And by the way, not to cast any aspersions on attorneys, but I have good friends that are attorneys and do documents, but they will come to me and ask me questions about how to title things in, or how to name the trust as contingent or primary beneficiary. So anyhow, we have forms for this, and I'm going to try to pull them up and see if we can do that or not. Here we go. So we've got some forms that we've created over the years, and this happens to be the insurance company notification. We'll get back to that one in a minute. But here's a retitling form that we use that basically tells whatever financial institution it is that I or we have established a revocable living trust, name of the trust, the date it was established, and that either we want to retitle our accounts with your institution into the name of the trust, or we wish to revoke and amend our previous beneficiary appointment and name the trust as either the primary beneficiary or the contingent beneficiary. So you got choices down here: the new owner, the primary, or the contingent beneficiary of the trust. Insurance company notifications. What I've found over the years is that some insurance companies, again, the trust is like an alter ego to the person, but if you got into an auto accident, as an example, and your insurance company was put on the notification that somebody was injured, if the opposing attorney named you and named your living trust as well, some insurance companies like to have that the trust named on the policy. I don't know that they could successfully contest it, But one of the big things that your insurance does for you is that it not only provides some money there if you were at fault in an accident or your home burns down or something like that, but an insurance company also gives you legal defense. So if you have let's say you're involved in an auto accident, and we had a client a couple of years ago whose husband was killed in a crosswalk by a tool company truck driver, and that claim went to almost $2 million. Well, the insurance company not only paid out on behalf of the truck driving company, but they also provided legal defense and paid for that legal defense. So an important thing here is just naming all of the parties so that everybody gets the legal defense coverage. So could the insurance company, or would the insurance company agree to defend only you but not your trust? I don't know, but I don't like taking chances, so we just inform the insurance company, and if they want to do anything like naming the trust on the policy, they do that. So as far as corporations, LLCs, and other entities, we've got some forms for doing that. I think I might have one here. But we also suggest that if you're going to transfer a limited liability company to your trust, as an example, you would want to take the extra step of going to the Arizona Corporation Commission and naming the trust on in their records as or naming the person as who's the manager of the trust or the member of the trust, naming them as trustee of their living trust. So, but one thing we do is we do the transfer documents. So what I've found, and I had one situation where we actually had a client years ago that signed all of their documents at the office, signed all of their transfer documents, and then kind of forgot about things. And they had an accident, I think it was about a week or two later, and lost their life. And we had to use the transfer documents to get everything transferred into the trust. So one thing I know is that if somebody does lose their life on their way home from the trust signing appointment, gets run over by a United Way Systems truck or something, if we have those documents signed, we're probably going to be able to get everything into the trust and thereby avoid probate in the process. So again, if you'd like copies of these forms, happy to send them to you. In terms of real estate, there it's either a warranty deed or a quitclaim deed. Personal property is picked up by the tangible personal property agreement in the trust. And I actually expand the language that Dennis Fox has in there to pick up golf carts, watercraft, mobile homes, trailers, digital currency, all of those kinds of things. So bank accounts, if you have bank accounts, basically most banks are going to want you to sign new cards. They're going to set up a new account in the name of the trust. So we just basically, we create a form for the person, but we tell them to just take their living trust portfolio down to the bank, and the bank is probably going to want to set up new accounts for them in the name of the trust. Credit unions, we have run into a situation with a lot of credit unions where they do not want to title a credit union share draft account or savings account into the name of the trust. They just won't do it. So what we do with them is we will do a POD, payable on death to the account, and that will take care of getting the account in the credit union transferred to the trust when the person dies. And then the other step that I take is that I usually have the client sign a power of attorney with the credit union. I don't rely on the power of attorney forms that we create in the trust portfolio, because our power of attorney forms can get stale. In other words, after they've been around for 2 or 3 years, a lot of financial institutions don't like to, they're a little bit fearful about accepting them. Their fear is that a later version of the power of attorney may have been created that they don't know about, and they don't like doing transactions on the older version. But if you use the credit union's power of attorney form, that is their form. That form is not going to get changed unless they know about it. So they are very comfortable with it. So like I say, the next logical step, set up the POD on that account, and then have your client sign a power of attorney form naming the same persons that they have set up as their trustees on their trust and agents under their power of attorney to be able to handle their credit union accounts. Promissory notes and land contracts, we've created the similar types of transfer forms that we have for the LLC to transfer those kinds of accounts into the trust. And again, on promissory notes, oftentimes they're done with family members or personal friends or someone like that. You're just looking for some kind of evidence that that person can make the additional promissory note payments to the trust itself, and everybody's happy with that. So land contracts, the same kind of a thing. The key here is that you get the assets titled in the name of the trust. If you don't, you could be looking at a probate situation or a conservatorship situation for the person because you haven't taken the extra steps of putting those assets in the trust. So real estate, you can do that with a warranty deed or a quitclaim deed. Bank accounts, again, go to the bank or set up the trust as beneficiary, POD, same thing with the credit union. Brokerage accounts, stocks, bonds, mutual funds, savings bonds, all of these things should be set up where they're entitled in the name of the trust. Now, most brokerages, if you went to Chase or Merrill Lynch or someone like that, they will have their own forms for putting that account in the name of the trust. It's just a matter of having your client go to them and ask for the forms, completing them, and filing them with the company. Most people don't own stocks, bonds, stocks or bonds individually anymore, but there's irrevocable stock transfers and bond transfers that you can use to do this if you need to do it. We have the forms, so we can make them available if you run into that kind of situation. Same thing with mutual funds. If you call the mutual fund company and tell them that you would like the mutual fund account put into the name of their trust, most mutual fund companies have their own paperwork to do that. They will send it out. The client can complete it and then again put the account in the trust. And again, then when the account's in the trust, it gets the protection from probate and the protection from conservatorship. Savings bonds, U.S. savings bonds are a little different critter. I actually have a website that you can go to. There's a federal bank in Kansas City. You can title these things to a trust. It is kind of a pain in the neck, but it can be done. Timeshares, I usually just have clients call the timeshare company because each company seems to have a different procedure that it wants to follow to get those timeshares into the trust. But again, this is just part of the job to get everything done. I think I've pretty much covered it. Here's the it's treasurydirect.gov if you run into someone that's got U.S. savings bonds. So I have done them. I actually had a client that had about 50 bonds one time. Oh, what a pain, but we got it done.
Jim, I have some of the question.
Yes.
The question is regarding powers of attorney that you create with the trust portfolio.
Okay.
Do you recommend the client record them with the county?
I guess my question would be, why would you want to do that?
I can think of a reason, but only one reason. If there's a possibility that the attorney, in fact, may be dealing with real estate related matters, my understanding is that that a power of attorney that authorizes someone to handle real estate related matters has to be recorded.
Okay. However, if the real estate was titled in the trust, the power of attorney would be ineffective anyhow. The person would be operating as a successor trustee under the trust, and the trust would give you the trust language normally includes all of the powers that title companies and so forth are looking for. So I love the government, but I don't love telling them things that I don't think they need to know. So it would be very hard for me to get excited about recording a document with the county recorder. And you know, again, unless it's a transfer, a warranty deed or something like that, which of course you have to record. But I would, if you have a living trust, unless there's some specific situation why you would not want to put a particular property in the trust, I would be more inclined to put whatever interest in that property you own into the trust.
Okay, and keep the power of attorney private.
Yep. As far as vehicles, boats, ATVs, and golf carts and that type of thing, you can change the title at the motor vehicle department. You can change title at Game and Fish, or you can just put these things on the assignment of personal property form. And it's been my experience that the motor vehicle department will accept that form. It's been my experience that Game and Fish will accept that form. So when you're changing title from the trust to the beneficiary, if you take that assignment of personal property form to the MVD, motor vehicle department, and show them that all of their vehicles are really deemed to be in the trust, I have never had a problem getting a vehicle transferred from the trust estate to the beneficiary. Again, how do I fund gold, silver, rare coins, livestock, furniture, furnishings? I just put all of those things in the tangible personal property agreement. And I do that because when you have a trustee that's dealing with beneficiaries, that agreement will basically show the beneficiaries that the person who set up the trust really wanted everything in the trust, everything to be under the administrative power of the successor trustee of the trust. And oftentimes that's all you're doing is just creating in the mind of the beneficiary a written form of a transfer. You're just confirming to that person that, look, Dad really wanted the gold and silver and his stamp collection and the rare coins and his horse. He really wanted all those things in the trust. And so it's okay for me to allow the trustee to take care of those or disperse them according to Dad's wishes. So if you had gold and silver, rare coins, what I see with a lot of people, they will want the coin collection to go to one of the kids, or maybe the coins, the gold is apportioned out over all the kids. There's only one horse. Dad only had one horse. There's 5 kids. The horse will not be amenable to be, cut in 5 pieces and dispersed that way. So usually, the person that created the trust is going to say, hey, I really want my horse to go to my daughter, Amy. She's a great rider. She will really appreciate it and that sort of thing. So all of these things are done just to convey the wishes of your clients, to put your clients' wishes in writing and to in a document, so that when they are incapacitated, when they die, everything is laid out as to what's going to happen, and they have incredible peace with that. This is something that people just really want to have done. Very important to them. Beneficiary designated assets. With life insurance, what we usually do is name the spouse as the primary beneficiary and the trust as the contingent beneficiary, unless there's some reason for doing otherwise. If it's a large estate, we might use an irrevocable life insurance trust. If it's an estate where the person, one of the persons was a doctor or an attorney or someone in a higher profile situation where the estate could be sued for some reason, then again, you can do things differently for one reason or another. So I just kind of look at, but most of the time, the spouse is going to be named as the primary beneficiary. The trust is going to be named as contingent. Same thing for 401k, 457 plans, 403bs, 401a plans for city workers and IRAs and so forth, or simple Roth, SEPs, and annuities. In most cases, the surviving spouse gets to get control of that account without any tax implications. And so you want them to be named as the primary beneficiary. The only reason where they might not be is if they're incapacitated, as an example, and they're just unable to handle the life insurance or handle the annuity or the IRA and that sort of thing. So, so again, for naming the trust as primary beneficiary, it's probably going to be in a situation where there is no spouse, or where the spouse is, or I'm sorry, where there is a spouse and the spouse is not incapacitated, contingent, where there are kids and you want spouses primary with the kids as contingent, then I name the trust as a contingent beneficiary. Corporations, with corporations, what you'll find with most people that have corporations, most people have LLCs today because they're so much easier, but you will find some old corporations around. Most people that have corporations that were set up in the state of Arizona that I encounter, very few of them ever issued stock in the first place. So they really should issue stock shares to themselves. But if they've done that, or even if they have not done that, then issue new stock shares in the name of the person as trustee of their trust, whatever the name of the trust is. And what that's going to do, it's going to provide continuity where that corporation is going to be transferred into the trust. And when that person is incapacitated or when that person is deceased, the successor trustee is going to be able to manage that asset. Limited liability companies, we kind of hit this before. You can use the transfer forms that we use, but definitely want to contact the Corporation Commission, use their amendment form to change the member or manager name to their name as trustee of the living trust. I like to notify home and auto insurance companies and title insurance companies. I've heard somewhere that a title insurance company, if the title is in the name of the trust, that there is some possibility that they may not have to defend title of that property. I've never seen it personally, but I read about it somewhere, so we always notify the title insurance companies. That way, if they have a problem, they can let you know up front. Any questions at this point? And I know we've skipped over a number of different things, some of which I'm assuming you already know. But if you have any questions and you don't think to ask them now, but they come up later, you've got my email information. Shoot me an email, and I'm happy to answer questions. So I guess we're going to take a break, Don, or are we going right in?
I have a few questions for you.
Oh, okay. Fire away.
All right. So one question is, if you have a pour-over will, sometimes those items not specifically named are subject to probate. Why is that if it is essentially put into the trust?
Well, it is my understanding that the purpose of the pour-over will is and again, the trust is kind of like a funnel. The idea is to get all of your assets funneled into the trust for distribution according to the terms of the trust. So when you have a pour-over will, you might be picking up an asset there that's not in the trust at this particular point, or somebody wonders, hey, is this thing really in the trust? It's not, we didn't retitle it. It's not mentioned in the tangible personal property agreement. So the idea there with that pour over language is to just take all assets that belong to that person and say, I want them in the trust. I want the trust to be the place where they're going to be distributed to my heirs. Does that answer the question, Don, or did I?
I think so. I think so.
Okay.
Okay, I have a couple questions about trustees. Are there any circumstances? Well, one of the general questions is who should be the trustee, and then kind of a follow-up question to that was, can the trustee ever be someone other than the settlor or the trustor, or whoever owns the trust?
Great question. I'm going to take the second part of that question first. And I have a slide on this. I didn't include it in this presentation, but when your client sets up a trust, there are three positions in the trust. There's what's called the donor or the grantor or the settlor. That is the person that is creating the trust document and putting their assets in it. That will be your client. Then there is the trustee. The trustee is the manager of the assets. That will be your client while they're alive and not incapacitated. And then there's the beneficiary.
Jim, can you repeat that last part? You faded out for a second when you started to talk about the trustee.
The trustee is the manager of the estate. A trustee is kind of like a personal representative under a will or an agent under a power of attorney. Basically, it's the manager of the estate. So while your client is alive and healthy, they are the trustee as well. And then the third position is the beneficiary. The beneficiary is the person that gets to spend the money and have the fun. And while your client is alive, they are the beneficiary of their trust. So they're all three persons. When they become incapacitated, at that point, they will give up their duties as trustee, but they're still the grantor or the settlor or the donor. They're still the person that created the trust and the only person that can change it. But they can't manage at that particular point. Or when they die, they seem to lose all interest in managing their estates at that point. So that's when the trustee steps in. Now, most people like to name their children as trustees. And Don, I think I'm going to ask you to repeat that first part of the question because.
So one of the questions was who should be the trustees and who should be the successor trustee, and then a kind of a follow-up question is, are there any circumstances where it would be appropriate to name someone other than the trustor or settlor as also the trustee in a trust?
Okay. All right, I'm going to get that first one. Who should be named as trustees? I think there's two qualifications for a trustee. The first one is honesty, integrity, because when you're serving as a trustee, you're serving as a fiduciary. And that's the highest level of accountability that there is. When you serve as a fiduciary, you are doing everything to protect the interests of the other persons involved, the beneficiaries, and if the trustor is alive, the person that set up the trust, if they're incapacitated, then you're protecting them as well. So the first qualification I like is someone that you can trust. The second qualification is someone who has just a reasonable level of competency in terms of handling financial or other matters. You don't have to be a superstar. There's an attorney could help you administer a trust. We've helped people administer trusts, but I think the most important thing is just someone that you can trust, someone that's going to carry out your wishes the way you want them carried out. That's the most important thing. Usually when a trustor or grantor is not going to serve as their own trustee when they're incapacitated or when at their death. Of course, if they die, the surviving spouse, who's also a trustor, could serve obviously at that particular point, and also if the person is incapacitated. But if you're incapacitated, if you're deceased, you're not going to be serving as your own trustee. At that point, some successor is going to serve.
Do you
answer?
Yeah, I think that answers it. How many alternates do you typically recommend? Like, what you're saying is that in the beginning, when you first set up the trust, provided that the trustor is competent, the trustor is probably also going to be the trustee in charge of their estate. But thereafter, within the body of the trust, you're going to name one or more trustees, or successor trustees, I should say. And how many do you recommend that be named?
I like 3 deep. I like a primary choice and then 2 successors. I've been doing this for over 40 years. We've never gotten beyond the second choice. Although I have to tell you, in one situation, we had to redo a trust because all 3 of the successor trustees were deceased. So that's one of the reasons, I guess, when you'd want to redo them. But I like 3 deep. That's just a personal thing. That way, if the primary can't do it, you've got a backup. If the backup can't do it, you've got a third choice. And in most of the trust documents, I know that the beneficiaries can, if all of the named successor trustees are out of the picture, the beneficiaries can vote to name their own successor trustees. So that language is in most documents. Does that answer the question?
Yes. Another follow-up kind of question I received that's kind of related, but actually before I ask that question, just to kind of throw this in there, for those of you that don't do a lot of trust or just getting into it, one thing I hope was obvious by the exchange was that if you have a trustor that is either already incompetent or they're just, I don't know, they've got some issues, either they're very old or they just have some issues where they're not managing their finances, you certainly can set it up with a trustee, either co-trustee to act with that person to manage their estate, or just somebody else to be the acting trustee, one or more people to be the acting trustee from the very beginning. And you can obviously name co-trustees or co-successor trustees, I should say.
Yes, I'm going to give you 2 examples of that. We had a situation recently where someone came in to set up a living trust, and it was a dad, and he was getting to the point where arguably he was still in the conversation, but he was getting to the point where he was beginning to get iffy as to whether he could really handle his affairs or not. So we actually amended the trust at that point, or restated the trust to add his daughter as a co-trustee. And there was one other child, there was a brother. So I had the brother come into the office, and when we signed the documents, and also at the time when we added the daughter as the co-trustee. So now we had all of the beneficiaries involved. The dad, who was again beginning to slip, but arguably understood what he was doing. The daughter, who was going to be the co-trustee, and the other son, who agreed to allow the daughter to be the co-trustee. So basically everybody was involved there, and we went ahead and set up or added the daughter as the co-trustee. I had a situation years ago where I did a trust, and we had a gal that was one of the witnesses for the trust, and And after she witnessed the documents, she and I talked, and she said, I would like to set up a trust for my husband and myself. And in the case of her husband, she was finding socks, or silverware in the underwear drawer, socks in the wash machine, things like that. So arguably, you know, he was reaching a point where things were pretty iffy. So I called an attorney friend of mine and I said, you know, they're asking me to set up a trust, but I do have one of the spouses here that, you know, no doctor has declared him incompetent yet, but I'm pretty much assured that if they did go to the doctor, that would happen. And so I said, what do I do? And the attorney said, well, if you're not going to change any of the who's going to get what, if his kids are going to get, you know, everything that they would have gotten in the current will, just go ahead and do it. So we did it. And when we got him to sign his part of the trust, it took me all day long to get him to sign his signature, you know, where he had to sign on the document. But we got it done, notarized. He did it in front of a notary. Got it all done, and then later on, his wife went back to his doctor, and his doctor said, "I can't believe that you know, you hadn't done something like this before," because he was definitely at the point where dementia had set in. So. But I'm not saying that that's a practice that you would want to do, but it's something we did back at that time. And the attorney that I talked to gave his blessing on it, said, go ahead and did it. We did it. And he has since passed away, and the kids got all of his estate, and his wife was able to act as the successor trustee for him, and it all went well.
Do you have time for a few more questions, or do you have to continue on with your presentation?
No, let's take the questions.
Okay, all right. I've got several more. And if you have a situation where a client comes to you, or a prospective client comes to you about setting up a trust, but they already have one or more of their children, let's say, or whoever it may be, on all their bank accounts, you know, as the beneficiary on their, you know, on whatever financial accounts that they have, and they give some resistance to the idea that they may want to take. What can you provide any, or are they really fact specific or situational? I mean,
well, you faded out on that, but I think I understood the question. Again, I don't think we can give them legal advice one way or another, but I do tell a story about a picture of a mom and her son that appeared on the back page of the Wall Street Journal years ago. The son was on there because he was a broker and he did some dastardly thing to his clients and he was being sued. Mom was on there because she had named son as the joint tenant with rights to survivorship on her home and on her bank accounts and her investment accounts. So basically, when son was getting sued because he was a joint tenant on all of her accounts in her home, her assets were up for grabs, so to speak, in that lawsuit. Well,
we lost you there for a second. We lost you there for a second. Can you tell what the son did again?
So the son had done some dastardly thing with his clients, and he was being sued. And because he was a co-owner on mom's bank accounts and investment accounts in her house, her assets could be brought into the lawsuit as well. So it's just a dangerous thing to do, and I just don't think it's a great idea. It's if you have your assets in joint tenancy with another person, with your kids, as an example, a lot of people do it. if they get sued, you could lose those assets. Or if they get divorced, those assets could be up in the divorce proceedings as well. So just not a good idea. You really can't tell people what to do or what not to do when you're in our position. Although as a certified financial planner, I can give a little bit more on the advice side there. But once they understand that those assets could be up for grabs if the person gets sued, I think in most cases, they're much more amenable to setting up a trust because you can accomplish the same purposes inside the trust.
Okay. A few more questions if you're up for them.
Okay.
One question, there's a question that's, what about changing ownership of firearms?
Well, I guess most firearms, today can be, if they're not Class 2 weapons, they can be sold individually without notification. I think there you have to be very, very careful, but as to what you do. But in most cases, if people have shotguns or rifles or pistols and that sort of thing, if they're going to leave them to specific beneficiaries in the trust, we usually use the personal property form where they can list those items and who they want to give them to. And at this particular point, I don't think there's anything in the law that restricts that transfer. But I have to say to people, boy, you got to use some common sense as to who you leave those guns to.
Okay. Another participant asks two questions. First of all, wanted you to repeat your email, please. And then also a question about how you charge for helping people with administration and funding.
I don't charge for funding. We just build that into our cost of setting up the trust. If we do administration, then we kind of look at the complexity of the situation, and we'll help them do the forms, and I'll give them some advice. I usually run that part of my business under my CFP, Certified Financial Planner, and I'm a registered investment advisor. So we can charge for giving financial advice. So usually I do it on an hourly basis. If I look at the situation and I realize it's not going to be that complicated, I will tell the clients we normally charge $250 an hour, but we'll put a maximum charge of X because I pretty much know that unless something comes up that's we just can't see, that I'll be able to give them the advice pretty quickly.
Okay. All right, next question. How do you handle real property in the name of an LLC so it passes through the trust?
Well, if the real property is owned in the LLC, then we just want the LLC in the trust. You don't want to take the property necessarily out of the LLC, you want to keep it in there, but you do want to have language either in the LLC operating agreement and or in the trust permitting the successor trustee to manage that piece of property. And I think what you'll find today, a lot of people have set up their own LLCs, used to be the corporations, but they never did any bylaws. They never did any operating agreement. So you will find that maybe the husband or the wife set up an LLC, but the husband is not even named in the documents anywhere. I had a client years ago that where the husband and wife went to Hawaii, and while they were there, the husband toppled over of a heart attack on the beach. The wife came home, husband had a business, her name was not on the bank accounts, it was nowhere on the business. Eventually she got it all sorted out, but it took her about 8 months to do it, and a lot of legal expense. So again, if you set up an operating agreement, or if you have a trust or both, the operating agreement should basically state that the trustee is allowed to manage the business. The trust should state, should name the LLC in the trust, and permit the successor trustee to operate the business. And you might want to put some qualifying language in there. We had one here recently where the husband's in business with his brothers, and he wants the wife to own the business, his portion anyhow, but he wants his brothers to be able to operate it. So that's a situation where you're going to have language in your document that's going to permit the brothers to operate the business and to take a reasonable salary from it, but yet continue to keep the ownership of the business if the husband dies in the wife's name. So these things can get fairly complex, but if you don't do it in your documents, you're going to have a heck of a mess when somebody passes.
Yeah, and just to comment that the process of changing the ownership of an LLC is very simple. So obviously the owner of the LLC is the member, and so it's just a matter of changing the member from you individually or your client individually to the name of to you as trustee of your trust, or your client as trustee of their trust, or the married couple. And that can be done using the eCorp online. It's a very simple, process that's done not instantaneously, but if I think the fee is $25 and it takes around 15 days for them to process it, or you can pay an extra $35 and they'll have it done usually within a week, and the effective date of that transfer is typically retroactive to the date that you submitted it. But bottom line is it is a very simple process to get that done for a client.
Right, and if you've never done it before, and I've been in a lot of situations where I've never done it before, I start with the end result in mind. In other words, in the end result, you want to be able to have the successor trustee be able to manage all of those assets. So you may have to make some phone calls to find out how to make that happen. That's the worst case scenario. Or you could talk to someone that already is doing trusts and find out how to do it. I guess the point I want to make is that we all had to start at some place. We all were in a period at one time where we had absolutely no idea what we were doing, and we stepped into a strange situation just because it had to be done for somebody. So nothing wrong with that. We're here to help. We can help you, or you can just call the financial institutions or call the Corporation Commission and ask them how to do something, and they can tell you. But we, as a group of legal document preparers, I think one of our strengths is that we have a lot of people in this group that are very smart, and they know how to do a lot of things. And honestly, if I don't know how to do something, I know people in this group that do, and I will call them immediately and find out how to get it done, or refer my client to them to get it done.
And Jim, I'm receiving a plethora of text messages asking for you to repeat your email address, please.
It is Jim T, Jimt like turtle, at iloveeps.com. So I love, LOVE, EPS like Edward Paul Sam.com.
Thank you. And I just have a couple more questions, and one of the questions was when you spoke about Dynasty Trust. I'm getting some feedback here. When you spoke about Dynasty Trust, are there other provisions in a trust? Let's say you don't have a Dynasty Trust, but can you comment on other provisions in the trust that might protect against creditors or situations where you have beneficiaries who are either too young, too incapacitated, or have issues such that so the trust can hold the money back or the assets back or the distribution back because of the condition of the beneficiary?
There are, and again, it depends on the document. When I first got started doing this, I saw trust documents that were 3 or 4 pages long. And obviously, there weren't a lot of provisions in those documents at that time. Today, they're about 30 pages long. And the reason for that is that we are just becoming a more complex society. So I can tell you in the 4 trust documents that there is language in there to the extent that if a beneficiary is abusing substances or is a spendthrift, the trustee actually has the power to pay on behalf of that person, not give them the money. I'm thinking of language in the 4 trust documents that says that even if the beneficiary reaches the age where they would get the complete distribution of the trust, if in the trustee's opinion, they're abusing substances, and usually there's some qualification for that in the document, or they're unable to handle their inheritance for one reason or another, the trustee can actually withhold dispersion of those funds at that point. So yeah, there is some in a good trust you'll see that kind of language. I get asked to evaluate people's trusts a lot, and what I tell people is, look, I cannot give you a legal opinion. I'm not an attorney, but I do know how to read, and we can read we can read your trust provisions, the ones that are in there that may not reflect your wishes. And we can read trust provisions that are not in there that might reflect your wishes. So I think we can let people know what they need to know without giving them legal advice.
Okay. Let's see. One more question. Can you do a beneficiary deed for real property owned by an LLC to a trust?
I'm going to have to defer to you on that one, Don.
Well, I would say no, because the LLC never dies.
Yeah, and I would say a beneficiary deed, that's more of a personal distribution anyhow. But if the property is already owned by the LLC, the operating agreement could state what happens, to the property actually after the death of the member.
Yeah, that's right. I should clarify. There are ways. You're right. Yeah, I guess I should take that back. I guess you could do that if it's tied into the death of the beneficiary.
The key is in all of these things.
You'd be transferring the title to the property. You'd be transferring. You can do a beneficiary deed for an LLC or a partnership, really, that transfers upon your death the membership interest to the whoever it is that you're leaving it to. But again, if you have trust, you wouldn't need to do that. You just make the member the trust, and that would deal with that issue. Does that make sense?
That would make sense, right? The key in all of this is to have something somewhere in writing that expresses your wishes, because usually you're going to be asking a financial institution to do something that you want them to do after the death or incapacitation of the owner, and they're not going to do it unless there's something in writing that gives them the legal right to make that to do that thing that you want them to do.
Right, but bottom line, in answer to that question, to my knowledge, you can certainly do a beneficiary deed transferring the membership interest to the LLC to whoever you want to have it, but you wouldn't be able to just do a beneficiary deed from the LLC. Well, I don't know. Yeah. Anyways, I'll stick with what I said. I'll stick to my story before I get too confused.
I wouldn't do it that way. And again, I had a friend of mine years ago that says, Jim, it only costs 25% more to go first class. And sometimes when you do things cheaply, it's that old thing of you can get your honey directly from the hive, but you might get stung in the process. So usually what I would say to people is, you know, you can do things the cheap way in life, but cheap it seldom is. So why don't we do it the right way? And I think you'll be much happier with the outcome. So.
Okay, Jim, we're about out of time. Anything else you want to say to wrap up your presentation?
No, I'm done at this point. I know the last time that when Carol Aragon Montgomery spoke, and by the way, it's hard to follow her. She just knocked that ball out of the park. But she did talk about business continuation, and maybe this is something we can talk about in a subsequent CE class. But if you ask me for a copy of the presentation, you will get some information on business continuation in there, no extra charge. And I think it's just a topic that we need to deal with within our group.
Okay.
And that's me too.
All right. And I just want to throw in a little plug for, while Jim is obviously very knowledgeable about the living trust, about living trust in general, this is an area that hopefully many of you are considering that you can seek to become competent at providing. I hope this presentation that Jim gave maybe encourages some people to take a step towards providing those services, much needed services in the community right now. So anyways, I thank Jim for his presentation. Was fantastic. And now I'm going to take over and going to do the last word of the day. Oh, let me get in here just 1 second. Okay. Okay, so we're going to do the last word of the day, and then I have a couple comments to make about our next webinar, and then we'll be all done. So the last word of the day is balloon. So write that word down, balloon. And then remember to receive your certificate of attendance in the class. Please email me all 3 of the words that we had today, and I will promptly send you back a certificate, at least fairly quickly, usually, that day, but at least by the following day. But I want to thank everybody for participating or attending the seminar. We had, I think, 49 people attend, which is fantastic. And don't be shy about giving me feedback. We're getting more and more into doing these webinars, and I'm sure we have some challenges periodically, but we'll get better as time goes on. And hopefully at some point we can get back to doing the in-person seminars as well. As the economy opens up a little bit more. But that will be it for this seminar. And I just want to mention that we're having another webinar, I should say, next Saturday at 9 a.m. from 9 a.m. to 11. It's a 2-hour, 2 credit hour seminar, and the title of which will be Back in the Saddle. So operating your LDP business as the Arizona economy reopens. And I'll be giving that presentation. We'll be discussing various topics like just in general dealing with the court, maybe the county recorder, other government entities, what changes or just different issues that you may have to deal with moving forward in light of the COVID-19 situation. We're going to talk about reopening your business if you haven't already done so, establishing safety guidelines. And I'm hoping to have someone that comes on for a little while with me that talks about incorporating video conferencing into your business, like using Zoom or Microsoft Teams, which is what we've been using for the last couple of webinars. I've been asked to also talk a little bit about the new remote and e-notary rules and how you can apply to do that, because obviously that could be an important service you can incorporate into your business in view of all the changes in society that seem to be going on. But that's all I have for today. I will be sending out a notice probably tomorrow, another notice about the webinar for next weekend. So please sign up for that on the website. I will send out the instructions on attending the webinar by Friday, and I hope to see all of you attend next Saturday at 9 a.m. So thank you very much, and we're signing off. Have a good weekend.